Welcome to CM Guide podcast series. Today, we're embarking on a deep dive into the intricate world in construction contracts. Specifically, we're dissecting how claims are handled and how engineers make their critical determinations under two widely used frameworks, the FIDC Red Book 1999 and its more recent, substantially revised counterpart, the FIDC Red Book 2017. Our mission here is really to cut through the often dense legal complexities and give you a real shortcut to being well-informed. We'll pinpoint the most important changes, unpack some surprising facts, and help you understand not just what shifted between these two editions, but crucially, why it matters and, well, what practical impact it has for anyone involved in a major construction project.
That's it exactly. Effectively navigating these contracts is absolutely crucial for success and, frankly, for avoiding costly disputes. The 2017 edition, in particular, introduced some truly significant shifts. They were clearly designed to encourage much more proactive contract management and, push for earlier resolution of issues. We're going to delve into those nuances today, especially around the pivotal moments when notices are given and how the engineer's entire role has evolved from maybe a seemingly simple arbiter to a far more defined and powerful figure.
Okay, let's unpack this then, because it really starts at the very beginning.
Right.
The fundamental mechanism for making a claim. For those of you familiar with FIDIC 1999, what was the standard approach back then, and how did FIDIC 2017 introduce such a, monumental change to this foundational aspect?
Okay. What's truly fascinating here, and quite a strategic shift, is how FIDIC's 1999 handled claims. It essentially had two distinct claims procedures running in parallel. If the employer needed to make a claim, they looked at subclause 2.5. If the contractor had a claim, they went to a completely separate path, subclause 20.1. Think of it like two different rule books for claims, depending on who was claiming. In a major fundamental shift, FIDI 2017 now combines both employer and contractor claims under a single unified clause 20. It's one rule book for everyone.
Okay, so one clause for all claims now. On the surface, that sounds like a step towards simplicity, maybe clarity. But I have a sneaking suspicion there's more to it than just a mere renumbering, right? It feels like FIDR rarely does something just for simplicity's sake.
You've hit the nail on the head there. This is absolutely not just a renumbering. The length alone tells a huge story. If you look at the sheer volume of text, 1999 subclause 20.1, the contractor's claim clause covered just over one page.
Right, just one page, yeah.
But the 2017 clause 20, it expands to 4.5 densely packed pages. This massive increase isn't about adding unnecessary bureaucracy. It fundamentally shifts the burden onto both parties. It means that to successfully navigate a claim in 2017, you need meticulous record-keeping, a deep, almost forensic understanding of process, and impeccable procedural compliance from day one. It's less about winning arguments with a compelling story and more about flawlessly executing procedure. Missing a step, forgetting a deadline, or an incorrectly worded notice could be catastrophic, no matter how strong the merits of your underlying claim might be.
Wow, a 4.5-page rulebook for claims compared to just one. That's a huge jump in length, and it really drives home the message about meticulousness. So more detail means more rules, more rigor. Does this expanded section lead to a clearer definition of what a claim even is, or does it just add more layers of complexity that make things, harder to understand?
No, it definitely leads to clearer definitions, which is crucial. The 2017 edition introduces clear, new defined terms. A claim is now explicitly defined as a request or assertion by one party to the other party for an entitlement or relief. This distinct definition is vital because it helps differentiate a claim from a dispute, which is now clearly understood as an unresolved disagreement under the contract. This separation is key for clarity throughout the entire process. Before, these terms could sometimes be used interchangeably, causing confusion. Now, the pathway from a claim to a dispute is much more formalized.
That distinction makes a lot of sense. Almost like a claim is a formal request, and a dispute is when that request hits an impasse. So it's not just about what you're asking for, but the stage of disagreement you're at. Are there any other new concepts introduced that aim to improve how potential issues are handled early on, before they even become formal claims?
Yes, absolutely. And this is a significant move towards proactive management. The explicit introduction of advance warning under subclause 8.4 in 2017, while a similar concept existed in 1999's program provisions, specifically subclause 8.3, encouraged some proactive notification of future events. 2017 formalizes it and elevates its importance to a whole new level. Both parties are now explicitly required to advise the other and the engineer of known or probable future events or circumstances which may adversely affect the work, increase the contract price, or delay execution.
So it's really about getting ahead of potential problems, almost forcing transparency from the outset. That's a significant shift in responsibility, putting the onus on both sides. But what's the real teeth behind this advance warning if there's no direct penalty for ignoring it? What's the stick?
You've hit on a critical point there. While there's no direct sanction, like a fine, for failing to give an advance warning, its strategic importance is immense. Firstly, it underlines the expectation of a genuinely proactive approach to contract and risk management from day one. Secondly, failing to give an advance warning can be considered a default under the contract, which could lead to complications down the line. And thirdly, and perhaps most crucially, if that unwarned event later leads to a claim, your entitlement to things like an extension of time or additional costs could be significantly reduced. Imagine trying to claim a delay from an unforeseen event that you knew was probable but never warned anyone about. It would be an uphill battle, to say the least.
That's a subtle but powerful consequence. Makes it a critical strategic move rather than just a polite suggestion. And you mentioned a condition precedent earlier that sounds like a very high-stakes requirement. Can you tell us more about what that entails for the parties involved? What happens if you miss that?
This is really a golden rule in FIDIC 2017. Giving a notice for a claim is a condition precedent to securing your entitlement. This isn't just a suggestion, it's like a final buzzer. If you don't hit that button, if you don't give the correct notice within the specified timeframes, you might irrevocably lose your right to claim entirely, no matter how strong the merits of your underlying claim.
Wow.
This is a very strict gatekeeper, and your claim is essentially dead on arrival. It's designed to ensure absolute procedural compliance. I've seen situations where a contractor, perhaps understandably overwhelmed by project complexities, missed a critical notice period, and it cost them millions. It's a brutal but undeniably effective enforcement mechanism for procedural rigor.
That puts a lot of pressure on diligent contract administration, doesn't it? So we've seen how the very filing of a claim has changed, demanding more rigor from both sides, pushing for proactive warnings, and introducing strict procedural gateways like condition precedent notices. But once a claim is submitted, who's the first arbiter, the first line of defense, so to speak? This brings us to the crucial figure of the engineer, whose role has also undergone a profound transformation from 1999 to 2017. Here's where it gets really interesting for those who thought they knew the engineer's position.
Indeed. In 1999, the engineer's determination process under subclause 3.5 was quite concise, just 2 short paragraphs. The engineer would consult with both parties and, if no agreement was reached, make what was simply described as a fair determination. This determination was binding unless challenged under the old Clause 20. It was a fairly straightforward, almost brief procedure, often interpreted as the engineer acting primarily as the employer's agent, even if trying to be fair.
And how does that compare to 2017? Did that fair determination principle carry over, or did the role truly shift?
Oh, the change is monumental. In contrast, FIDI 2017 subclause 3.7, now aptly titled Agreement or Determination, spans 3 full pages.
3 pages for that section alone.
Yes. This increased length itself reflects a significantly more detailed and complex set of obligations for the engineer. But the biggest, most pivotal change is philosophical. The 2017 Red Book explicitly states that the engineer is to act neutrally between the parties and is not deemed to act for the employer. This is a very, very important clarification regarding their impartial role, shifting them from what might have been perceived as primarily the employer's agent to a more independent, almost quasi-adjudicator.
That's a significant emphasis on impartiality. While that sounds ideal on paper, how does one truly ensure that neutrality in practice, especially when, the engineer is still engaged by and paid by the employer? Are there common pitfalls or challenges to this impartial role?
That's an excellent, critical question. Look, while the contract states neutrality, in practice, the engineer often works day-to-day with the employer and their team. It's just the reality. The challenge is maintaining that contractual impartiality in the face of ongoing relationships and, potentially, pressures. FIDIC tries to bolster this by making the engineer's decisions subject to clear timelines and external challenge via the DAB. It pushes the engineer to make objectively defensible determinations, knowing they can be reviewed. The pitfall is, of course, if the engineer fails to live up to this neutrality, it can severely undermine trust and just accelerate a dispute. That's why the procedural mechanisms around their determinations are so important.
These mechanisms, then, must be incredibly strict, especially with timelines. What about the strict deadlines for these determinations, and what happens if the engineer doesn't meet them? That sounds like it could cause a lot of issues if there's no clear resolution path.
You're right to highlight the deadlines. The 2017 Red Book introduces much tighter time limits and deeming provisions. This is a crucial concept, where an action is assumed to have happened if it doesn't happen explicitly by a certain time. For a detailed claim, the engineer is obligated to encourage agreement between the parties within 42 days of receiving the final claim or any additional particulars. If agreement isn't reached, they then have another 42 days to issue their fair determination. These are hard deadlines, no longer flexible guidelines.
Okay, hard deadlines. This raises an important question. What if the engineer misses these deadlines? Do the parties just wait indefinitely, or does something automatically trigger?
Not at all. This is where those deeming provisions become so powerful. Under 2017 subclause 3.7.3, if the engineer fails to issue an agreement or determination within the stipulated time,
Yeah,
the claim is deemed to have been rejected.
just like that. Rejected.
Just like that. Deemed rejected. This isn't just a gentle reminder or delay, it's a powerful legal trigger. The claim is automatically considered rejected, effectively pushing it straight into a formal dispute. This deemed rejection then automatically escalates the matter, allowing it to be referred directly to the Dispute Avoidance Adjudication Board, or DAAA. It removes ambiguity, but forces swift action. It's a mechanism designed to prevent claims from lingering in limbo.
So it forces the issue. No lingering unresolved claims, which I guess is a good thing for project momentum. And for the parties, what's their next crucial step after an engineer's determination or even a deemed rejection? Is there a window to challenge it, or is it final and binding immediately?
This is where the Notice of Dissatisfaction, or NOD, under 2017 subclause 3.7.5 becomes absolutely critical, non-negotiable. If either party is unhappy with the engineer's determination, or if a deemed rejection has occurred, they must give a NOD within 28 days of receiving it or of the deemed rejection date.
28 days, that's not long.
Not long at all. It's a very strict window. If an NOD is not given within this strict 28-day window, the engineer's determination is deemed to have been accepted finally and conclusively by both parties. This means you irrevocably lose the ability to challenge it further through the DAB or arbitration.
So silence means acceptance.
Exactly. In plain terms, if you don't declare your dissatisfaction within that window, your chance to fight that decision is gone forever. It's a very strict procedural gateway designed to bring absolute finality to decisions quickly. And this directly links to the 2017 definition of disputes we mentioned earlier. Only a matter for which a NOD has been given is truly considered a dispute that can be referred to the DAB and subsequently arbitration.
Okay, so if a claim becomes a dispute, and importantly, an NOD has been issued, it then moves to the Dispute Avoidance Adjudication Board, or DAAB. How does their role in the overall dispute resolution process compare between the 1999 and 2017 editions? Is it just a name change from DIB to DIB, or is there more to it in terms of actual power and function?
Well, both editions feature a board, the DIB in 1999, and the DIB in 2017, which is typically composed of 1 or 3 members. These members are jointly appointed by the employer and contractor, and they're paid a monthly retainer split 50-50. This shared payment mechanism is intentionally designed to ensure impartiality and fairness. Neither party alone is controlling the purse strings, which helps foster neutrality.
That makes a lot of sense for maintaining neutrality, but what about the avoidance part of the DIB in 2017? Does that signal a different emphasis, perhaps trying to stop disputes before they fully escalate?
Absolutely. The 2017 edition, by renaming it the Dispute Avoidance Adjudication Board, emphasizes an even greater focus on dispute avoidance. The board isn't just there to adjudicate after the fact. They're also tasked with helping parties avoid disputes where possible, maybe by offering informal opinions or facilitating discussions. It's a more proactive mandate. And a key enhancement in 2017 is under subclause 21.7. If a party fails to comply with a DAF decision, which are intended to be immediately binding, even if not final, the other party can refer the matter directly to arbitration.
Directly, without any further steps.
Directly, without needing to go through further DAB procedures or even amicable settlement attempts first. This significantly strengthens the enforceability of DAB decisions compared to 1999, where compliance could sometimes be a prolonged struggle. Now, noncompliance can quickly lead to a final, legally binding arbitration.
That's a powerful lever, isn't it? Streamlining enforcement and putting real teeth into the DA's decisions, it really pushes parties to resolve things earlier. Beyond claims determinations and dispute resolution, what other major standout changes did the 2017 Red Book introduce that truly shift the landscape of managing construction contracts? Are there other major areas that saw significant shifts that our listeners should be aware of?
Yes. Several areas saw significant updates that profoundly impact project risk and party rights. Take termination clauses, for instance. In 2017, the employer's right to terminate for contractor default now includes new explicit triggers. These include failure to comply with a final and binding engineer's determination or any DEAAB decision subject to materiality, or if the delay damages cap is exceeded.
Yeah.
And many of these conditions were often just particular conditions in 1999, meaning they had to be specifically added for each project. But in 2017, they're standard provisions, so you're signing up to them automatically unless amended.
So more predefined grounds for termination for the employer, which adds another layer of procedural risk for the contractor. What about the flip side, or other types of termination? Specifically, the employer's right to terminate for convenience, which is always a big one.
You're absolutely right to focus on that. The employer's right to terminate for convenience was very significantly modified, big time. In 1999, if the employer terminated for convenience, the contractor was generally only entitled to costs incurred, plus demobilization. It was a relatively, shall we say, cheap exit for the employer.
Right.
However, in 2017, if the employer terminates for convenience, they are now required to pay the contractor loss of profit and other losses and damages suffered as a direct result of the termination. And this is crucial because this entitlement is explicitly carved out from the standard indirect and consequential loss exclusion, which typically prevents claims for things like lost profits on other projects or broader business disruption.
Okay, so it's not just costs, but actual loss of profit on this contract.
Exactly. Loss of profit and other direct losses from this termination. This change potentially exposes the employer to a very significant financial impact, making them think twice before pulling the plug on a project simply because it's no longer convenient. It truly shifts the balance of risk there.
That's a huge change for contractors and certainly makes an employer think twice, maybe even 3 times, about terminating for convenience. It adds a substantial financial disincentive. What about the contractor's ability to protect themselves financially when the employer might be in a shaky position? Any changes there?
Yes, for the contractor, 2017 also significantly strengthens their ability to request reasonable evidence of the employer's financial arrangements. This can happen if certain specific conditions are met, such as a large variation being instructed over 10% of the accepted contract amount, or there's a delayed payment. If the employer fails to provide this evidence within 42 days, the contractor gains a clear right to suspend work or even terminate the contract.
That sounds like powerful leverage.
It is. It's a powerful new leverage for contractors, designed to safeguard them against financially unstable or slow-paying employers. It's a proactive mechanism to avoid becoming entangled in a financially compromised project.
That's a fantastic new tool for contractors, addressing a long-standing pain point in the industry. And finally, what about the day-to-day administration of the contract? Are there any procedural updates that affect how parties simply talk to each other, the basic communications?
Yes, even simple communications have stricter rules in 2017, reinforcing that emphasis on diligence and documentation. Under subclause 1.3, any notice or communication must not only be in writing, but must also specifically state if it's a notice or other communication, and importantly, include a reference to the relevant contract provision it relates to.
So you can't just send an email saying, do this.
Pretty much. You need to be formal. This aims to dramatically improve project management at the site level and prevent future disputes that so often arose from unrecorded verbal instructions or vague communications. For example, a directive to change something on site now needs to clearly state it's a notice of instruction under a specific clause like 13.1, or it might not be legally binding. While it does place an additional administrative burden on the parties, yes, more paperwork, more formality, it's absolutely essential for clear, auditable project management and ultimately dispute prevention.
So if you had to distill all of this down for our listener, what's the single most important takeaway from this deep dive into FIDIC Red Book 1999 and 2017 claims and engineer determinations? What's the one thing that should really stick with them?
Look, the biggest takeaway, the absolute core message, is the profound shift in FIDIC 2017 towards increased procedural rigor and the absolute necessity of proactive contract management. The emphasis on detailed notices, the introduction of extremely strict time bars, especially that non-negotiable 28-day notice of dissatisfaction for engineers' determinations, and the engineer's clarified neutral role, all point to a contract that demands constant vigilance and crystal clear, meticulously documented communication from all parties, all the time. Ignoring these procedural gateways, particularly those related to notices and deemed rejections, can irrevocably impact your rights and entitlements, potentially costing you millions, regardless of the merits of your case. It truly underscores the critical importance of not just understanding the specific version of the FEI contract governing your project, but being relentlessly diligent in its application from day one. It's not just a set of rules, it's a procedural minefield that demands absolute respect.
That's a powerful insight. Vigilance and clear documented communication, and understanding those procedural gateways as potential minefields. It feels like 2017 is less about what you should do and much more about what you must do and exactly when you must do it. Something to truly mull over for anyone navigating complex projects. Thank you for guiding us through this complex but absolutely crucial topic. Before you go, please don't forget to share, like, or subscribe. Also, have a look at other episodes and visit CM Guide website for better insights on this topic.